Chapter 8 deals with pleadings, and just a reminder that we are expanding considerably on what is in the chapter because we are focusing on Pennsylvania rules of civil procedure as well as the county local rules. So make sure that you're following the rules that we're covering in class as well as what is in the textbook. So just a few things before we get into the actual parts of a complaint. The first one is that is what is actually considered a pleading. Sometimes people make the mistake and think that every document filed with the court is a pleading, but that is not correct. Rule 1017 states what are considered pleadings in Pennsylvania state trial courts. And those are a complaint and an answer, a reply to a counterclaim or cross-claim. The answer itself may also contain a counterclaim and cross-claim, and they would be pleadings as well. The one that you are not to worry about right now is the preliminary objection that's listed in the rule, because we discussed preliminary objections at the beginning of Civil Lit 2 next fall. So those are what are considered pleadings. So that is what we are focusing on in this class this semester. Another thing to be aware of is the two different ways that a lawsuit can be started in Pennsylvania state trial court. Most cases are started by filing a complaint. So that is obviously where we're spending most of our time, because in practice that is likely what you're going to be doing is drafting complaints if you work for an attorney who is in court. But Rule 1007 talks about the other way that we can start litigation, and that way is with a précipe for a writ of summons. So again, this is Rule 1007 in the Rules of Civil Procedure, and we can commence an action in court by filing a précipe for a writ of summons. Now, précipe is kind of a strange word, and I don't know if you can find it defined anywhere outside of a legal dictionary, but it basically is a request. So I don't know why they went with précipe, but it's basically a request that you're filing with the court. And if you look at the rule, this document that you would file for a précipe for writ of summons is very basic. It would be just a document that would state, to defendant, you are hereby notified that plaintiff has commenced an action against you. So it's a very short document, very easy to draft and file. Now, if an attorney was to start an action by filing a précipe for writ of summons, they would still have to file a complaint. This basically buys them a little more time. Usually within 20 to 30 days after the précipe, a complaint would have to be filed. So this doesn't take the place of a complaint, but it is a preliminary step that can be implemented. And there's basically two reasons why an attorney would want to file a précipe for writ of summons instead of a complaint initially. First reason would be negotiations. Say it's a case where you send a demand letter, you've been negotiating back and forth with the other side, and this is one of your bargaining tools that you're using to try to convince the other side to settle the case. Kind of a, look, we're really serious about filing a lawsuit, so we're going to go ahead and file this précipe because within a month we're going to have to file the actual complaint, and we're ready to proceed. We talked about with the demand letter how it's very common to state that, if this case is not resolved through this non-litigation manner, that we are ready to proceed with legal action. This filing of the précipe would be one of those first steps. So it's not something that has to be done, but it might be helpful in negotiation. So that's one reason to use the précipe for writ of summons. The other reason is if our client either comes to us pretty late, or if we have a lot of investigation to do and we're coming up on the tolling of the statute of limitations, and we need to get something filed in court because if it expires, then our client is out of luck and cannot file a lawsuit. So this would be the way we could file something in court. It would toll the statute of limitations. It would stop it from running, and it would then give us, 20 to 30 more days after that to be able to either finish conferring with their client, investigate the case, draft the pleading, and get it filed. So that would be the second reason if we're running up on the expiration of the statute of limitations. So that is a way you may never see that in practice, but it is a very useful tool and can be a way to really protect our client's case in court if we're not able or for any other reason do not feel able to file a complaint at that time. So let's look at the actual complaint. So this first page basically just sets out the different sections of a complaint. So two documents that always have to be drafted with the complaint is cover sheet and notice of defense. So these are each their own document. So normally when you go to file a complaint in state trial court, you're going to have three documents with you: a cover sheet, a notice of defend, and the complaint. Now you're going to have multiple copies of many of these documents, but those are the three documents that you're going to have. In the complaint itself, you're going to have the attorney information, so the attorney who's representing the party, their information. You're going to have the caption, the introductory paragraph. And I apologize for the dog barking. It's just something I can't always control as much as I would like to. So we're going to have the introductory paragraph. Then we're going to get into the numbered paragraphs. And the first part of the numbered paragraphs are always dealing with the background of the case: jurisdiction, venue, party. So things that we have already covered in this class, those are going to be in those first paragraphs of the complaint. Then we're going to list what is called the common fact allegation. So this is basically the story of our client. So we talked the other day about our factual theory, the factual story of our client's version of events, different ways of saying the same thing. That's going to be the next section of numbered paragraphs. Then we get into the counts. The count is a cause of action, the legal theory of recovery. So we're going to get into the allegations of the elements of each of the cause of action that we may have, and then the facts that support those elements of that cause of action. Then at the end of every count, you're going to have what is called a prayer, which is the request for relief. Always begins with the word wherefore. That's how you know it's the prayer. In Pennsylvania, complaints, actually all pleadings, have to be verified by the party, which is basically just a statement that the party is saying that to the best of their knowledge, everything in this document is true and accurate under the penalty of perjury. And so that paragraph has to be there, and then the client has to sign. And then the attorney also has to sign and date the document. So those are there's different sections of a complaint. Those probably sound familiar to you because we do discuss those in the intro course as well. And if you've ever seen a complaint, you have an idea of what this all is. So let's get into the different documents or the different sections in the different documents that are on this list. So first, the cover sheet. The state rule that governs cover sheets is at 205.5. There's also local rules. So make sure you understand how the state rules of civil procedure and the county local rules, how they work together. So the state rules tend to be broader, sometimes more general, and then the state rules allow the counties to develop their own local rules. These rules have to be consistent with the state rules. They cannot take away or contradict anything in the state rule, but they can add and clarify requirements. So we're going to be focused on Dauphin County local rules. The link to them is in the website section in D2L for this course. You can also just look up dauphincounty.org and locate them that way. I'll give you the specific link to the cover sheet in the materials. Different counties can have different rules. So you always have to check the local rules of the county in which you are filing a lawsuit. You cannot assume that the rules are the same. If you ever need clarification or need to verify what documents you need to file in a county, call the Prothonotari's office of the county in which you're going to file the complaint. I know, for instance, I think it's in Lancaster County, there are some types of cases where there's two cover sheets that you have to file in a particular case. So it really will just vary. But the cover sheet is it is required to be filed, and it's usually a one-page sheet, and it usually just has basic information: the name of the parties, the type of case, the amount of damages requested, the attorney's name. So they're not difficult to fill in. It's usually fill in the blank types of forms, but you need to file it. Keep in mind, if you show up at the Prothonotary's office and you don't have the right documents, or they are not correctly filled out, you are likely taking everything back to the office with you and doing them correctly, and then going back to the Prothonotary's office. So you need to, we need to do the best we can to get things right the first time, and it makes our time much more efficient, and makes it easier on the people who work in the Prothonotary's office as well. Notice to defend is the next document. So the notice to defend is in Rule 1018.1, and this also has corresponding local rule in Dauphin County. So notice to defend in other courts, such as federal court and other states, it is called a summons. Pennsylvania State Trial Court, we call it a notice to defend. A notice to defend has to be drafted for every case that we file. So every time you file a complaint, you have to have a notice to defend. That is the document that is put on top of the complaint that is served upon the defendant. And it is a document that says you have been served a complaint, it has been filed in court against you. You have 20 days to respond to the complaint. If you fail to do so, a default judgment can be entered against you. So it's giving them all the basic information. It's usually a page long, although there can be additional information. But as I said, it notifies the defendant that they're being sued, gives them the time frame in which to file an answer, which in Pennsylvania State Trial Court is 20 days. It can be longer in federal court and in other states. What happens if they fail to respond? And it also will give them the local lawyer referral service number. Every county has a lawyer referral service number. This allows them to get in touch with an attorney who will frequently meet with them on a reduced fee basis for that initial consultation. And then if they decide to hire them, they would have to work out the fee arrangement just like they would with anyone else. But it at least gets them, hopefully in the door to talk to an attorney. So the local Dauphin County's notice to defend is at local rule 1018.1. So you'll notice that the local rule is going to have the same number as the state rule of civil procedure. And so that's the way you will always know, is there a local rule? You just go into Dauphin County, find the local rules, see if that number exists, and if it does, see what it says. So you can find a copy of the notice to defend in Dauphin County a couple different ways. You can go into the local rules under court departments. You can also go under publicly elected officials and find it there. But you have to draft this in every case. Now, Dauphin County adds a paragraph regarding mediation services that are available. And Dauphin County also requires that the notice to defend also be in Spanish. And so the notice to defend in Dauphin County is about 3 pages long, because you have your first page, which is your typical summons. You then have a paragraph for the mediation notice, and then you have the same thing in Spanish. And again, there's going to be similarities from county to county, but it may not be the exact same document. So if you're filing in a county in which you are not familiar, you do have to check their local rules. Okay. Then getting into the complaint itself, the next or the remaining slides is going to deal with what information has to be on the complaint itself. So the attorney information has to be there. So again, we have a local rule in Dauphin County that states what information has to be there. And you will see on the complaint assignment, it has, the name, the address, phone number, fax, or email, and, basically all the contact information. So that is what has to be included. Now in Dauphin County, they want this in the top left-hand corner of every document you file with the court. That way the court knows that who has filed this document, because it's at the very top of the first page. Some attorneys will still put it at the very end of the document after their signature. That is what I always did, because that was the norm at the time. But you would have to flip through to the end of the document to see the attorney's contact information. So it makes sense to have it at the top of the first page. So to get to the actual details, you go to Local Rule 205.2A. And also, and this is an important thing to keep in mind, this document, the complaint or the answer, the first document that the attorney signs